Hello, my name is Sergio Ardila, and I will be talking about how to evaluate your case. This is part 2. In the first part, I covered the basics, and now today I'm just going to talk about different variables that work with the basics that I discussed in the first video. Like in all my other videos, none of this creates an attorney-client relationship, and all the information that I'm providing here today is information that you can find out online yourself or in a book. So none of this is legal advice, and this is just for informational purposes only. So let's get to it. So as you might remember in the first video, I discussed in its very basic form the 3 components where a workers' comp claim in Georgia derives its value. Now today I'm going to talk about how these variables affect the evaluation over those 3 components. So we're going to look at non-litigation versus litigation cases. We're also going to look at compensable versus denied cases. We're going to talk about burden of proof. We're going to talk about some variables, not an exhaustive list, but some that determine the strength of your case. And we're also going to talk about who is the person that will be making a decision if we have to go to court. Now, when we're talking about the value of the case, again, we're talking about how much the insurance company would possibly pay on your claim when we're talking about settling the case. Now, you can have your case in litigation and still be discussing the possibility of settling your case. Settling your case is something you can discuss at any stage of the process. Now, like I said in my other video, it's always voluntary, so you do need to have both parties desiring to settle the claim. Now, if your claim is a non-litigation claim, most likely you are in a situation where the insurance company is giving you all the benefits that you merit at that point. The majority of analysis and data evaluation comes down to the other video where I discussed the most basic elements of that. If your case is in litigation, it means that your attorney or yourself or both have decided or have judged that you are not getting some of the benefits that you merit based on the facts of your claim. Now, just because your claim is in litigation doesn't mean that everything has been denied. In many situations, the insurance company can just deny certain parts of your claim. So we're going to look at the first thing, which is a compensable claim versus a denied claim. Now, in terms of workers' comp in Georgia, a compensable claim simply means that the insurance company has paid or is paying you weekly workers' comp checks. You might be in a situation where the insurance company is giving you medical benefits, and based on the facts of your claim, whether they have to give you weekly checks or not has not arisen. Maybe the insurance company got with the employer and they're giving you a light duty job during the time that you're getting your medical treatment. In that scenario, they wouldn't have to pay you any checks. And because they haven't paid you any checks, this is not a compensable claim, even though they haven't flat out denied any checks. You understand what I'm saying? You can be in a situation where they have not paid you any checks, but your claim is not yet compensable. In order for a compensable claim to exist, they have to have given you weekly workers' comp checks, which, as you remember, is one of the 3 components that I explained last time. Now, if the insurance company believes that your claim does not fit within the workers' comp laws in Georgia, they can deny your claim. And if your claim is denied, it is evaluated differently than from a compensable claim. If your claim is compensable and they're giving you checks, then both attorneys and the insurance company can just do the math to figure out how much they would have to pay you during the time that your claim goes forward. If your claim is denied and they're not giving you any checks at all, then you don't really know if they would ever have to give you any checks ever or any medical treatment, because they're saying that you're not entitled to either checks or medical treatment or anything. And they're saying that they would want the judge to make that decision. You're also saying that as well when you and your attorney requested a hearing and brought your case into litigation. So that's the basic difference between a compensable claim and a denied claim. A compensable claim being worth more because at that point the insurance company is already accepting your claim as one that fits within the workers' comp laws. They're saying, we do owe you money under these 3 categories, and then you just go back to the other video and do the analysis there. If your claim is denied, they're saying, we don't believe we owe you any of these 3 benefits. And then it is up to your attorney and ultimately the judge to decide if you are entitled to these or not. Nobody knows at that point. And because nobody knows, that's why we get to the other variables here, including the strength of your case, some variables that fit within the strength of your case. And then coming up now is just the burden of proof. In its most basic form, the burden of proof, what it is the law imparts onto one party or the other who it is that needs to go to court and prove their case. Initially, it is the claimant who bears the burden of proof in Georgia workers' comp cases. And there are different burdens of proof. Usually the one that you hear on TV is beyond a reasonable doubt. That's usually the burden of proof in criminal cases. The state has to prove that against somebody who's allegedly committed a crime. Now, the burden of proof in workers' comp is different. It is a preponderance of the evidence. What does that mean? A preponderance of the evidence means 50% plus 1. So that means initially the burden of proof is the claimant. The person bringing the claim needs to prove by a preponderance of the evidence, 50% plus 1, that they were hurt in the job and that they are entitled to these benefits. If you and your attorney make a case and it cuts right down the middle, so the judge is saying this could go either way, the judge is not sure who to believe, then the claimant would lose. You would lose in that situation. You need to prove your case by a preponderance of the evidence, so more than 50%. That's something very important to understand initially, because once you start evaluating the claim and you look at the testimony, the medical evidence, and the credibility, you might have a set of facts that cuts right down the middle. And if it cuts right down the middle and you don't have the burden of proof, that's good for you. It means you might go to court and win. But if you do have the burden of proof, then you might need to reassess everything. And it might be a good time to think about settling your claim, because you might be likely to go to court and lose. Now, when looking at the strength of the case, we're looking at what's more likely to happen if you go to court. Is it more likely that you win, or is it more likely that you lose? Depending on the answer to that question, it's going to either motivate you more or less to settle your claim if you have the opportunity to do so. And some of the 3 things that I'm going to explain here today, there's a longer list, a lot more variables that you look at when determining the strength of your case, but this is some of the most basic ones. First one is the testimony. If your case is in litigation and you're getting ready to go to court, it's most likely the insurance company would have already taken your deposition, or is getting ready to take your deposition, where they ask you questions about your claim, about your injury, and you answer those questions. There's a whole different video on depositions that I can provide as well. The insurance company is also likely to have their own witnesses. So maybe they might bring the employer's manager or supervisor or co-worker, and if this claim is in litigation and they believe that you're not entitled, they might have the manager to go and testify that you never said you were hurt, that they saw you playing basketball 2 days after your injury, or many other examples that I've seen throughout my practice. When you're trying to figure out the value of your claim, you evaluate everybody's testimony. You evaluate your testimony, try to figure out if your narrative makes sense, if it follows a logical path, and you do the same with the testimony of the employer witnesses. You also look at medical evidence to determine the value of your claim and the strength of your case. Does the medical evidence corroborate or support your narrative? Does the medical evidence support that your body parts, the same ones that you're alleging that you're injured, that those are the same ones that are being diagnosed? Is there a claimant maybe that said that they injured their leg, but when they go to the doctor, they're talking about their shoulder? That would not be good, and that would weaken your claim. So you look to see if the medical evidence corroborates the narrative of the injury. Did the claimant take 4 months to go to the doctor after they're alleging that they were injured? These are things you look at. You also look at the credibility, and the credibility is huge in a workers' comp claim. If for whatever reason anybody puts their credibility on call, that would be dangerous for either side. Because if a judge does not believe what the claimant is saying, the judge might not believe the entire claim. If the judge does not believe what the employer is saying, they might not believe the defense at all, and the claimant would win. And that comes down to the last part here, that in a workers' comp claim in Georgia, you're only looking at one judge. It's only one judge only that's going to be deciding the entirety of the claim. That's why many times in a settlement, they might not give the claimant 100% of what he or she's entitled to, but because the claim might not be very strong, it might make more sense to accept the settlement rather than let one judge decide, and maybe the judge decides against the claimant and the claimant gets nothing. So I hope this video helped you understand some variables behind the evaluation of your claim when you're looking at litigation and strength of your claim.